Yo, I couldn't wait to get to the crib so we can talk about what happened today in the YSL trial. It was simply unprecedented. It's your boy Tay Biz. Let's go. Welcome to Tay Biz TV. Look here, we got some stuff that we got to talk about. Let me tell you something. Today was day 100 of the YSL trial, and my boy, Pituitary Glanville, he had some stuff to say today. And I'm telling you right now, it was pretty unique. All right. Let's go over it a little bit. Kayla Bumpus is good. She's not going to be, she done the hearing for Kayla Bumpus is completely dismissed. Glanville tried to defend himself on why he think the ex parte was proper to do. We'll get into that. We'll get into the video. And also, we're going to talk about the recusal. What happened? What happened? Doug Weinstein pulled a fast one. Shout out to Doug Weinstein. Hey, man cooked. See, he fooled everybody. He made everybody think like, oh, I filed the motion incorrectly. Everybody kept saying that. No, Doug had some stuff on his mind. He said, look here, I know if I do this writ, if I do this emergency petition, if I give it to him, to Glanville, he's going to deny it. Glanville has denied. He's the only person I know that can judge his own accusation. It's amazing. However, Doug Weinstein said, you know what? I'm going to go past the appeals court. I'm going to take it to the Supreme Court because I know they're going to reject it. As a matter of fact, there was an interview that he did. I think he either did it with Megan Cuniff or Talk That Law. I'm not sure. But he did an interview stating that he purposely did that because he knew Glanville was going to deny the motion. So what happened? The Supreme Court said, listen, you got to take it back to the Superior Court. You got to take it back to where it's supposed to go. But Glanville cannot rule on this particular motion. So therefore, it was a dub. All right. It was a dub for the court. I mean, for the defense, really. You know, it was a dub today. Glanville, again, like I said, he tried to defend himself on why he thought the ex parte meeting was proper. He put up some cases where there was a judge and a witness and the prosecutor without the defense and all that kind of stuff. But the problem is, though, Glanville, Pituitary Gland, the problem is that in those cases, they actually released the information to the defense. You were never going to say anything. You were never going to say anything. As a matter of fact, you threw the defendant's lawyer in jail. You tried to. You held the man in contempt. You sentenced the man for 20 days and on the weekends because you realize that if you refuse to allow this man to represent his client, it's going to be automatic mistrial. So you know what Ms. Love did? Ms. Love said, Your Honor, listen. We want to come up with a better way to properly execute what's happening with this particular motion here. I mean, because we want Mr. Williams to have a fair trial. Yeah, I know you do, because you don't want to have a mistrial. Okay. So what's going to happen? What's going to happen is the motion to recuse or to remove Judge Glanville has already been assigned to a judge. Her name is Belinda Edwards. Shout out to Belinda. Okay, shout out to Belinda. Belinda has the case to recuse Glanville, to look at the case, see what it is. Who is Judge Belinda Edwards? Well, She was the Fulton County Juvenile Court judge for a nice period of time. Then she became the Fulton County's chief judge for juvenile court. And now she's a Superior Court judge for Fulton County. And she's been a Superior Court judge since 2017. All right. The lady is well, listen, from what I heard, from what I know, people told me that she about that business. She stand on business. Okay. So we're gonna go ahead and play the actual proceedings that happened today. And the court is in recess until they figure out if they're going to remove Glanville or recuse him, because he had to recuse himself, so that way the case can go to somebody else, see if they'll take it or not. It's in Belinda Edwards' hands. We won't have court until, court is pretty much paused. The trial is literally on pause right now. This is absolutely beautiful. All right, let's check out the video without further ado. Let's go.
All right, folks. As you all are made aware of, last week the court was going to do an in-camera review of the ex parte proceedings on June the 10th of 2024. In considering whether or not to have an in-camera discussion or review of the records, this court has decided to release the entirety of the transcript.
You better.
Of those proceedings as courts won. And I'm going to take judicial notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A, and that'll be marked as courts 2. So the transcript will be court 1. His immunity agreement, Mr. Copeland's, will be court 2. Mr. Copeland, who was represented by Mr. Jonathan Melnick and advised of his rights and obligations during the proceedings on Friday, June the 7th, which will be marked as courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt, and that will be courts 4, Mr. Copeland's order of contempt. Mr. Melnick informed the court that he was not going to be in attendance of any further proceedings, as he would be on leave effective 10 June of 2024. The court informed Mr. Melnick that his leave, or I had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 with Mr. Copeland. Mr. Melnick relayed that attorney Kayla Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with the court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Ms. Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Kayla Bumpus, attorney or ADA, Ms. Adrian Love. Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess from 9:34 to 10:03 a.m. to await Mr. Copeland's arrival. The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were attorney Bumpus, Ms. Hilton, the DA's investigators Long and Hamilton, the court and security personnel, deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall. The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with attorney Bumpus from 10:17 a.m. to 11:28 a.m. The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. The court arrived in courtroom 1C at 11:49. That will, and the transcript of those proceedings starting as of 11:49, or when the court presumed that held the proceedings on 10 June in courtroom 1C 2024, that will be marked as courts 5. The proceeding in 1C commenced on the record at 11:52 a.m. A lunch recess was had at 12:51 p.m.
You're going through the whole itinerary, y'all.
The parties returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking and then Mr. Steele later that afternoon was held in contempt. However, he was allowed to continue representation of Mr. Williams. The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told to him at that time. Jurors Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m. The court asked Mr. Steele again whether he received ex parte information, and that would be at 5:59 p.m. Mr. Steele's counsel, Ms. Ashley Merchant and Mr. Alex Susor entered the courtroom. Mr. Steele was held in criminal contempt. That order of that contempt will be marked as court 6, and the proceedings concluded at 7:41 p.m. The court further takes judicial notice of the following statements proffered by Attorney Steele, Brian Steele, in open court upon information and belief stated to the court, which are still unknown. There are 6 assertions that Mr. Steele proffered in front of the court. Those are contained within the transcript of courts 5, the proceedings that are held on the 10th of June of 2024 in courtroom 1C, which the court has already said will be part of this order. The first assertion.
Wow.
And the transcript bears out exactly what Mr. Steele said. So the court is paraphrasing the 6 assertions that Mr. Steele made. They're more aptly and more eloquently put in the record. The first one
Come on with it, brother.
involves his concern that supposedly in chambers, this honorable court reporter, court at times, district attorney or district attorneys before the DA's office, as well as investigators, sheriff, and deputies, Mr. Copeland and his counsel met together. None of the defense team, to his knowledge, were present. Second assertion he makes is that Mr. Copeland intended to plead the Fifth Amendment.
Look at him eyeing him down, bro. Eyeing him down, boy.
Third assertion is that Mr. Copeland, as a party, was sworn, and Mr. Steele asserted that this particular conversation was, in fact, a critical stage, and that the defendants had the right to be present. The fifth group of assertions involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness, to include the court, involving allegations of coercion and witness intimidation, and that his counsel had the right to be present. And the sixth assertion that was.
Yo, and just to be clear real quick, these people right here that you see, these individuals right here, Remember, this is Ashley Merchant's co-counsel right here that was representing Brian Steele when he was held in criminal contempt for not snitching, basically. And it was attorney-client privilege or attorney work privilege. And this is, who is this? This is Gabe. This is the attorney that represents Kayla Bumpus. All right. Remember, there was a motion to quash and to recuse Judge Glanville for the hearing that Kayla Bumpus had on June the 25th that got held back to supposedly July 3rd. However, because of the written emergency petition and the file motion of the writ of mandamus towards Glanville, and it went to the Supreme Court. The Supreme Court of Georgia said, you know what? You got to do it the right way, Doug. How about this? Take it back to the Superior Court, which you're supposed to do. But Judge Glanville cannot rule on his own motion. That's what the whole point is. The fact that he denied it 3 times to recuse himself, he denied mistrials. Now he cannot rule on anything. He has to recuse himself from the motions that are against him, and he has to recuse himself because he cannot judge on his own motion. So I just wanted to point that out real quick as well. Let's go.
Was made in open court was that Mr. Copeland admitted to killing Donovan Thomas. At some point after Mr. Steele was held in contempt by this court in the afternoon of June the 10th, it was brought to the court's attention, not at the court's request, by security personnel that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp.
Oh, look at that. Look at that. Hold on. Now, what Judge Glanville said, like, I saw y'all talking. I saw y'all spitting. I saw y'all mingling. But let me tell you something. That means absolutely nothing because Brian Steele already knew what happened before they even met outside on camera. So they have camera footage of them all talking, but the conversation that they were having, Steele already had the information. And so Kayla Bumpus did not tell Mr. Steele. As a matter of fact, on the lead attorney's channel, he interviewed Kayla Bumpus today, July 1st, today, and asked her, did you tell? She said no. But she didn't say who told, but she said, I did not tell, because he had the information prior to me even walking up, having that conversation on camera with him. So he was letting me know that he already knew. You see what I'm saying? And so when Woody said, you're fired, it's all good because Bumpus was not trying to be his representation in the first place. She was just there to make sure that she represented him on behalf of Melnick, so that way he either testify or not testify. You know, because they threw that immunity at him, and they also threw the fact that he can't use the Fifth Amendment. So that's another thing. So I just want to point that out as well.
Sought to investigate any facts of this involving this footage, and only considered it for the security and timeline of events that occurred on June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. And as I said, mentioned it only for the purposes of considering the security and breach of information that occurred within the court's chambers, not for whether or not that was truthful or not.
He trying it, man. He reaching now. Judge is reaching. The judge
Mr. Steele makes made three assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness, and this was a critical stage. And no, Mr. Copeland was a sworn witness. And third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any or procedural, substantive, or tactical advantage as a result of the ex parte communication. And the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver. And all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed, so everyone will have a chance to take a look at it and use it as they see fit. In this particular, and then the last part of 2.9 before the court goes on, if involves in pertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned earlier, I'm going to release the entirety of the transcript to you all to use as you see fit and before any other further examination of Mr. Copeland. I'll address the issue of the emergency nature of this particular hearing or this particular conference in front of the court. Is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-5-507. And that the conversations that were had in the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating, along with Ms. Bumpus, his lawyer, who was there the entire time, his witness's understanding of his immunity agreement. In consideration of this emergency nature, the court has taken into account a couple of cases I'll cite for the record. One of them is United States versus Adams, and that's 785 F. 2nd 917, decided in March the 31st of 1986. In pertinent part, presence of the accused. Although an ex parte conference to discuss threats against the witness is proper, district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. Presence of the accused. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed.
This dude right here is pulling out cases to defend himself right now.
Adams, the appellants contended the ex parte conference was improper and it violated their due process right to a fundamentally fair trial. We agree with appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional. Indeed, some situations, the trial judge may find an ex parte conference necessary. Cite La Chapelle, and that's LACHAPPELL versus Moran at 699 F. 2nd 560. It's a First Circuit case from 1983, where the court cites, in the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may, in rare circumstances, feel it necessary to confer with a juror or witness on the record, but outside the presence of others, including the defendant. One such conference may be where a juror witness, having been threatened, wished to speak with a judge privately about a threat. A witness may not feel free to discuss any threats in presence of the defendant or even counsel for the defendant. We agree that the First Circuit, that an ex parte conference is appropriate in that situation. They see United States versus Arroyo.
Got some information, y'all.
It's ANGULA. It's at 580 F second, 1137, pinpoint 1142, 1142, and 1141, 1142, Second Circuit case. Exclusion of certain defendants and counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threats. And they've got a citation for that being 439 U.S. 913. Although an ex parte conference discussed threats against witnesses proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. In this case, the court followed procedures to ensure the conference was fair. First, at no time was the substance of Pooley's inculpatory testimony discussed. And second, the entire conference was transcribed. And that's United States versus Watchmaker at 761 F second, 1149, 1985. Ex parte conference with frightened juror properly were transcribed and the judge's comments carefully framed. This court goes on to say in Adams, two aspects of this conference, however, disturbing. First, when the prosecutor began to impress upon the witness the distinction between being paid for testimony and afforded protection, the trial court should have called the conference to a close. The portion of the record quoted above indicates an attempt by the prosecutor to coach the witness on how to answer questions about inducements from his testimony. The court had already learned all it needed concerning the witness's fears and the prosecutor's plans for protection, there being no reason to participate in such coaching. Second problem occurred where Pooley took the stand. Defense counsel inquired about what inducements had been given for Pooley's testimony, and the prosecutor and Pooley both indicated the promise was the prosecutor would seek to enroll Pooley in witness protection program if he were in fear of his life. Neither related to the prosecutor's pledge to seek immediate protection for Pooley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made as in the ex parte conference were completely and precisely disclosed. Similarly, in this matter, the only thing discussed between the state counsel for Mr. Copeland and this court were the understanding of his immunity agreement. There were no other testimonial statements made by in terms of what Mr. Copeland planned to testify to that were induced or sought by the court. And the transcript in its totality will bear that out, and you can have a look at that. The court's also considered Bruner versus the state. That's 302 Georgia at 6, and this relates to the right to be present and what is defined as a critical stage and under the Sixth Amendment. Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings. Embodied within the constitutional right of the courts to a criminal defendant's right to be present, see and hear all the proceedings which were had against him on trial before the court. Ward versus the state, 288 Georgia 641, pinpoint 645. Violations of this due process right are presumed prejudicial, absent a waiver by defendant requiring a new trial. However, there were no violation of Bruner's right to be present. The right to be present attaches to any stage of a criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure. And that's Huff versus the state, 274 Georgia 110, pinpoint 111. Thus, a critical stage of a criminal proceeding is defined as one in which the defendant's rights may be lost defense is waived, privilege is claimed or waived, or one in which the outcome of the case is substantially
Yeah,
affected in some other way. And this
that's
particular
the reason
case,
why I
the
still
court
wanted
is of
why
the
Young Thug to
opinion
be there.
based on look at the case law that this was a proper ex parte meeting pursuant to 2.2 Rule 2.9,
The
as
judge
well
know
as
this is not good, man.
no
He
party
knows this
gained
is
any
not proper.
tactical
This is
advantage,
crazy.
and that the proceedings as a whole are released to will be in the terms of the transcript. So what was said can readily be seen and utilized by the defendants. Okay, and the court lastly took into consideration Talton versus the state. That's 368 Georgia Appeals at 313, and that involves a Sixth Amendment critical stage definition that was decided June the 21st of 2023. And in pertinent part, in many instances, remand will be necessary when the right to be present claim under the Georgia Constitution is raised for the first time on appeal from criminal conviction. So Mr. Steele's raised this at the appropriate time, and the court is in fact considering it. And the Georgia Constitution guarantees criminal defendant to be present, see, and hear all proceedings in which are against him on trial before the court. Criminal defendant's right to be present under the Georgia Constitution attaches to any stage of the criminal proceeding, which is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure, but the right does not extend to situations where a defendant's presence would be useless or benefit but shadow. And under the Georgia Constitution, defendant who is represented by counsel need not be present for portions of the trial that involve questions of law and consist of essentially legal argument about which the defendant presumably has no knowledge. It is well settled under the Georgia Constitution guarantees a criminal defendant the right to be present and see, hear all the proceedings in which are had against him or trial before the court. It's Prickett versus the state, 314 Georgia, 435 at 441 pinpoint. This right attaches to any stage of the criminal proceeding that is critical to the outcome of if the defendant's presence would be contribute to the fairness of the procedure. But the right does not extend to situations where the defendant's presence would be useless or benefit or shadow.
Here we go, guys. Here we go.
The court further takes no position on whether Attorney Bumpus disclosed confidential or attorney-client matters. The court takes no position on whether Attorney Bumpus violated the duty of candor to other counsels involved in this case. These two questions can be resolved by the State Bar of Georgia and our Supreme Court.
Mm-hmm.
The court further takes no position on whether Mr. Steele, his use of the June 10th proffered information, as his use on behalf of Mr. Williams falls within our guidelines as set forth in the Georgia Rules of Professional Conduct. The court's basis for having been explained on the record, a written order of this along with the attachments will be included in the record. And Mr. Banks, where are you? Sir, as a result of this transcript release, the court withdraws the show cause for your client and others who may be present who are present in chambers on the 10th of June of 2024. And as I mentioned earlier, we were going to have a show cause hearing on Wednesday, the 3rd of July. I am canceling that indefinitely. In fact, I've canceled all of that. So we will not be holding that particular hearing, okay? All right.
So Kayla good.
As a Then transitioning to the last matter the court wanted to put on record. Upon further review, this court will in fact enter an order sending Mr. Adams and Steele, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So this written order is entered. I will enter the order transferring it. And until such time as those two things are decided, then we'll be in recess until that time. And we will just inform our jurors that they're until they're not supposed to come back on Monday until Monday anyway. So I will have Deputy Ingram and Ms. Umana indicate to them that they are still on recess and we're continuing to work. So.
All right. So that is the entire footage of what happened in court today. But let's break this down a little bit. Okay. Let's summarize this for a minute. So we're looking at the fact that, first of all, Judge Glanville is going to release the full transcripts of the ex parte meeting, the unredacted transcripts. At first, he was going to give the defendants the redacted transcripts, and defendants was like, no, we're not. The lawyers, the criminal defense attorney said, we're not doing that. All right. So the Supreme Court is making it clear that if you're going to release transcripts, they have to be in full. They cannot be redacted. All right. That's number one. Also, all recusal motions will be heard by another judge, which means Judge Belinda, Edwards, which means all the recusals are going to just her. He's not going to take each person's recusal and they're given to one judge at a time or three different judges. All the recusal motions are going to one judge. Court is in recess until the recusal motions are heard. All right. So right now, the trial, everything is on pause. The jurors are on pause, which is very unfortunate for them. And I know that they have to be so irritated at this point because they haven't been in court for the last few weeks or whatever. Well, this would be the third week because Woody is not testifying clearly. You know, he's not cooperative on the stand. You know, and also Simone Hilton has decided to impeach her own witness, impeachment by contradiction. And this is the reason why we've been having all those hearings about the interrogation videos and jail calls and all this kind of stuff, because they're trying to impeach him. And he's already stated what I said back then were all lies. The prosecutors, the DA is like, we don't think you was lying. We think you was telling the truth. So we gonna take what you said back then, and we're gonna prove that what you're saying today is contradictory to what you said before. All right. So but at this point in time, the court is in recess. The show cause hearing has been canceled. All right. Bumpus' motion to quash is moot right now, for now. Okay. Glanville also made arguments for the record about why he felt like that his in parte meeting was proper, when we all know that it was definitely improper to do an in parte meeting, ex parte meeting, with a sworn witness that could possibly have Brady material on the inside of it. So inside that meeting. So that's another thing. He also clarified that he is making no assertions. So, and also Bumpus, he's making no assertions, that Bumpus violated any attorney-client privilege or did anything against the court. So she is gone. She is done. She's good. Now, what happened is this, though, is that I was watching the lead attorney today while I was at work, and she was in Houston. She didn't even show up to court today. She was in Houston, letting her attorneys do all the dirty work, because that's what you're hiring for. And so she talked about her attorney, Gabe, who has some type of relationship with the court, with judges, with other attorneys. I mean, he's a solid attorney, according to Ms. Bumpus. And so this is the reason why he was there, and that's why Judge Glanville said, "Hey, man, we good. We don't need to worry about it." You know what I'm saying? Now, I was looking up some information real quick because I'm curious about the immunity that they gave Woody. They never specified what type of immunity it was. So I looked up something real quick, and it says here, immunity comes in different types and may have restrictions. So it is important to understand the specific deal that a prosecutor is offering before agreeing to it. Two types of immunity. Number one, transactional immunity or total immunity. Sort of like what Donald Trump got today, but that's another video. Also, number two is use and derivative use immunity. Okay, so let's break down what these are. So total immunity provides a shield against any future charges based on any matter related to the testimony. All right. So the prosecution can still bring charges against the witness for matters that are unrelated to the testimony. The federal criminal justice system does not offer transactional immunity, but many states do. So when you see a trial that goes to the state or the Supreme Court of the state, that state has the right or to give that person total immunity, right? So the other main type of immunity is known as use and derivative use immunity. This comes with more restrictions and thus is more often offered by prosecutors. Use and derivative use immunity protects the witness from having the prosecution use their statements or evidence discovered from their statements against them. They are trying to use statements against Woody right now. This is the reason why they're going over these hearings. All right. Essentially, this produces the same result as if the witness invoked their Fifth Amendment privilege and did not testify at all. It allows the prosecution to bring charges based on the same crime against the witness, as long as the charges are based entirely on independent evidence from a different source. Whether that evidence is sufficient to convict the witness without using their statements can be left to the judge or jury to decide. Now, you must testify when you have immunity. Here are the limits on immunity. Typically, a prosecutor offers immunity to someone who has committed a minor crime because they believe it will help them catch or convict someone who has committed a major crime. Often, it arises in the context of organized crime, Rico, when the prosecution offers a subordinate immunity in exchange for testifying against the leader of the enterprise, Young Thug. If you agree to this type of deal, you must testify as promised, or you may face jail time and fines. So, when it comes to subordinate immunity in exchange for you being able to identify what this leader did in this organized crime, then you must testify. If you do not testify, then I got to go ahead and trip you up. I got to make sure that I can use something against you, right? And that's what the DA is doing. It says use and derivative use immunity protects the witness from having the prosecution to do this. But the prosecutor said, hey, he's not being cooperative, so we're going to impeach him. We're going to impeach him with statements that are contradictory to what he stated before, so that way we can go ahead and get some truth out of this whole particular proceeding. There's still no evidence of anything. RICO is an organized crime accusation. There's no drugs. There's no weapons that have been bought or exchanged through YSL. They're trying to pin the murder of Big Nut on YSL, on Young Thug and YSL, because they really don't have any other criminal evidence substantial concrete evidence of saying that this was an organized crime, that this was an enterprise that sold drugs. This was an enterprise that sold guns. This was an enterprise that had people, murdering people or whatever the case may be, or deleting people, excuse me. There is no evidence. So the only evidence that they have is that somebody deleted Big Nut. All right. Somebody deleted Big Nut, Donovan Thomas, and we need to figure out who it was. And it seemed like it's Young Thug because the vehicle that's in the video of the drive-by shooting looks like the vehicle he rented at Hertz. They had the Hertz manager from 2015. They had the Hertz regional manager from 2015. They had they don't know. They've never seen them. They can't remember if they've seen them or not or anything. So this was very, very interesting today. So Glanville right now is on pause. This whole situation is on pause right now. And so this is called staying the proceedings until we figure out the motion to recuse and what they're going to do with Glanville. So if you enjoyed this video, go ahead, hit the like button and share this video. Also, go ahead and leave a comment and let me know what you think about this. All right. I'm your boy, Tay Biz. Peace.